Hello again, and welcome back to the legal English world of intellectual property. This time, we're talking about patents, and we're going to explain exactly what a patent is and what can be patented. I know this might sound like a repeat from the first session, but I'll tell you just a little bit about myself very quickly. My name is Jeff Keiser. I'm a practicing lawyer from the United States, but I'm also a legal English educator and have been for the past 5 years. I love working in the language. I feel that lawyers use words as our weapons, and I love to help people become better at that kind of work. It's important to know the right words and how to use them to really get your points apart, especially when we're talking about arguments. Nuance is one thing that makes communication difficult in a second language. And that's what we're trying to bridge here. Trying to give you the tools to give you a little bit more nuance in your legal English classes. So, patents generally, they're granted for inventions or for designs that meet 4 general criteria. They demonstrate aesthetic design or functional utility, depending on whether you're applying for a design patent or a utility patent. Don't worry, we'll talk about those different types of patents soon enough. But we have to show novelty compared to existing products, inventions, or designs. We have to show that this is a new invention, that it's not just someone else's invention with a different name on it. To get a patent, we need to prove that our idea is unique and not obvious at all. And lastly, we need to provide a complete explanation of our design or invention. This may require using some high-tech computer-assisted drafting, or definitely someone drawing a picture of it. It usually won't work just with words themselves, and at least for me, I am not an artist at all. So I always need to pay somebody to help design the charts and the graphs of anything I'm working on. But these are the 4 things that make something patentable. Here are the common forms of patent. And in essence, the first 2 are what really matter in our profession. A utility patent is issued for the invention of a new and useful process, machine, manufacture, or composition. It also can be a new or useful improvement of an old system, but it still needs to be new and different enough. A utility patent could be for something like a new Gillette razor. It might improve on the old Gillette razor, but still could be patentable. Next is a design patent. These are granted to cover the ornamental design of an object that has a practical utility. These last 2 are fairly related in a way. They're very specialized. A plant patent is for a new type of seed that might grow a new kind of flower or a new type of grain that is more pest resistant, for example. GMOs are filled with plant patents. And finally, a software patent protects the inventions that come from a software package. There tends to be a little bit of overlap when it comes to software between a patent and a copyright, but patents might be the stronger option if you're presented with them. So, now that we've talked a little bit about what can be patented, this is what can't be patented. You cannot patent an idea. You can't say that I have a new idea for a new Gillette razor, that will do the job 10 times better. That's not enough. Likewise, a discovery or a scientific theory. You can't patent the discovery of an element, for example. Just because you find a new type of mineral in the earth does not mean that you're the only person that can use it. You cannot patent as an aesthetic creation. That is much more in the field of copyright. You cannot patent a presentation of information like a graph or a chart. And finally, you cannot patent a procedure for a surgical or therapeutic treatment. That one and the second one are really just for the furtherance of mankind. That if we could patent how to cure cancer, for example, then very few people would be able to afford it. And these choices have been made through the development of patent law. Aesthetics. This is a great word. And it really just means that it's a set of principles concerned with the nature and appreciation of beauty, especially in art. So this really does live in the world of copyright. Novelty. There's a lot of people that think novelty means like it's a joke, that it's a novelty item. But the real definition is that it's the quality of being new, original, or unusual. It's a new creation, a novel creation. The novelty of being a married man wore off is my example, and a little bit of a joke. A trade secret. I said we'd talk about this, and we will in passing a little bit. But this is something that a company has developed that is not known outside the company. Any information that's considered that gives one company a competitive advantage over its competitors is a trade secret. Now, why don't we copyright a trade secret? Well, the reality is, we don't want anyone to know what our trade secrets are, ever. And even by talking about it, by copywriting it, it gives the opportunity for some people to steal the idea. So now, I'm going to tell you something that will absolutely blow your mind. The formula for Coca-Cola is not patented, copywritten, or anything else. It has been kept within the Coca-Cola company since it opened and has never been exposed. And the real reason is most intellectual property rights expire after a time. We'll talk about the specifics later, but if you were Coca-Cola, you would never want that formula out. You would never want it to become part of the public domain. And so they've simply kept it in a safe in their big factory headquarters in Atlanta, Georgia, and no one has ever known it. So there is no patent on Coca-Cola. If you can figure it out, you can compete directly with them. But people have been trying that for more than 100 years without much luck. Okay, that's the end of our first patent class. The next patent class will walk you through the process of obtaining a patent. Until then, have a great day, and I'll see you very soon.